SJC-13191, HSBC Bank USA v. Tommy L. Morris and another.
Okay, Mr. Morris, I'll hear from you.
Your Honor. Yes. Your Honor and Chief Justice and Associate Justice, my name is Tommy L. Morris, and my wife's name is Mary L. Morris. She can be today. I just got out of the hospital. But okay. It is our home and our right to equal protection from this court and all other courts as to our property and the life of investment of our wealth and our place of retirement, our home, and our protection from a predatory loan, which is before this court. When the rights of the people are violated, and the legislator and the government have tried to protect us, can we be denied based on a technical reading of a small part of the law, ignoring its overall purpose and the flow of history that is part of it? It needs to be clear that we did not get any money from this scam. The money went to the parties that overvalue the homes. What we got was a house worth 5/7 of the mortgage that we signed for. We was told our one mortgage was going to be $1,400 a month. We was shocked to find that we had two mortgages loan, and we was paying $2,000 a month starting in 2005. By the end of 2007, we was paying $2,500 interest on it, which we had paid $50,000 total for the first 2 years. So we did not know it, but the brokers knew it. If we were informed about the unaffordable mortgage, we would have never bought the house. We were over 60 when we closed. We are African American from Brockton. The first city in Massachusetts to go majority minority. The 1997 Division of Banks letters named 6 states and federal law and 6 regulations for originate mortgage loans. All of these were violated in our solution. It's promised the bank that the brokers, they would be aggressively prosecuted if they violated these laws. The complainant violated many laws. We need to know if the court is going to hold them accountable. After a decade of discrimination, we was often told that we bought too much house. We clearly bought way less house. We was scammed into $100,000 too much debt. The Attorney General sued Fremont in 2007 for $10 billion. That case recognized my loan as predatory. We only got $2,000 settlement. There is no challenge to the fact that this is a predatory loan. The appeals court and the appellate agree that the Predatory Loans Act apply here to end discrimination lending practice to protect home buyers. And we argue in violation of regulation laws. What I understand is calling the common law concept like unconditional loan or countable loan origination. The law words was very broad and were supported to make sure that we was not denied a remedy. So you see section 15C, see our filing and the extensive history from our amicus from the Board Equal Protection Purpose Law. Its words make clear that the contract violation is like our shall not create a mortgage debt. They don't seem to come into a legal existence of at all. The real question is that the legislative act in this law is previous, and in previous laws like the Massachusetts Equal Right Act and the anti-redlining law to protect people from being put in illegal and immoral mortgage contract knowing it. Will we get justice? The interpreter is this law to say, as long as they willing to conduct a wrongful foreclosure on the contract that was never legal, they can get away with it. Then I do not know where we turn for justice.
Thank you. Thank you. Okay, Attorney Kia.
Chief Justice Bud. Chief Justice Budd, Associate Justices. Greetings, David Kaya for the appellants Tommy and Mary Morris. May it please the court. Your honors, this is a consumer protection case and a case about the regulation of a certain kind of contract. The core issue in this case is whether the Morrises have a valid defense under the Predatory Home Loan Practices Act, Chapter 183C, or Chapter 93A in a summary process eviction case to a complaint brought by a plaintiff who therein claims to have superior title by virtue of a foreclosure of a mortgage, and by that, a superior right to possession of their home. Among their other defenses, the Morrises asserted that this loan was prohibited by the PHLPA and Chapter 93A, and therefore the foreclosure is void and was therefore wholly ineffective to transfer their title to the plaintiff appellee. The Central Housing Court ruled and the Appeals Court affirmed that the Morrises did not have a valid defense or counterclaim under the PHLPA or Chapter 93A. Due to the time limitation, I will limit my argument to the PHLPA issue. The gravamen of the Appeals Court's holding involves the language in Section 15B2, in which the court says, in which it says in part, a borrower may at any time during the term of a high-cost home mortgage loan employ any defense, claim, counterclaim, including a claim for a violation of this chapter. The crux of the Appeals Court's holding is the legally operative effect it gave to the phrase during the term of a high-cost home mortgage loan. The holding is that because the loan was foreclosed, the term of the loan ended, and therefore because 15B2 could only be used during the term of the loan, the Morrises could not use any prophylactic protection the Act gives to them as consumers. But what does this phrase mean as applied here?
Can I stop you for a second? So I understand your statutory argument, and both dissent and the majority decisions of the appeals court are very, considered. So I'm trying to understand how this works. So under your view, we've got like a 30-year term. I can't remember what this term of this mortgage is. Was it 30?
They are.
So it's like a 30-year mortgage and they stopped paying in 2008. Right?
Yes.
So does that mean, and now this property was bought by the bank itself. So we don't have some other person coming in and getting hold of this. I'm just trying to understand the limits of this. So again, someone stops paying. It's now 14 years they haven't paid on the mortgage. And the term is 30 years. So, and even if this property had been transferred to someone else, they could still bring this action. Is that right?
I would say-
So I'm just trying to understand, are there no limits to this? That if a bank engaged in this and someone didn't pay and 30 years later, I'm just trying to understand how this is going to work in the real world a little bit.
Your Honor, this court doesn't have to decide all of those
Well,
questions.
it does, right? Because
You're implying is the good faith purchaser doctrine with no notice of any defenses or.
we've got those, under your view, again, we look at the term, it's 30 years. And I understand your reading. I'm just trying to understand how this works though. Okay, and also, does the act have a provision that allows the bank requires the bank to shrink the interest rate or anything like that? There's no middle ground here. Either the bank has it or this predatory loan is totally unenforceable even 30 years later. I'm just trying to understand how this
I've
works as
seen
a
these
practice.
adjustable rate mortgages where people don't understand. They have a payment that they're counting on, and then the very sophisticated mortgage contracts say it's tied to the LIBOR rate, which is the London interbank exchange rate for
I
all
get
of those
this.
things. And then what happened? My payment went from 1,400 to 2,000. But the point that I wanted to make today, while I have the time,
Well, I suspect Chief Justice Bud's going to give you a little time because this is kind of hard. So we're
Sure.
not going to let you go into.
it was
2
hard for
minutes.
me, Justice Capper,
So
too.
I'm just, again, I get your argument that the term means 30 years, whatever the term is, but I'm just trying to say you believe that even a good faith buyer would be out of luck. The way this works is this good faith, this defense can be brought years after the summary process.
Yes.
And can basically recreate possession.
The theme of my argument is that some contracts are illegal and wholly unenforceable, such as contracts to accomplish an illegal purpose. Doesn't matter how long it was. A court is never going to enforce it. We don't enforce contracts against minors except for the reasonable value of necessities provided. We have the statute of frauds that we inherited from England, which was enacted in 1677. And it starts off with no action shall be brought, and then lists several types of agreements and contracts that must be in writing and signed by the person to be charged in order to be enforceable. So there's no expiration on that. Here we have some high cost home mortgage loans that are legally originated and some that are prohibited entirely. And what I'm saying here is that those loans that are prohibited entirely by this act, they cannot be ripened into a legal mortgage by the act of foreclosure. Because if we have a body of foreclosure law that the legislature has entrusted the industry to do the right thing with, then how can we say we're going to let you use that trust to make a loan that was illegally originated and make a valid foreclosure title from that illegal loan? That's the crux of my argument today.
Counsel, can I ask you to address 15B itself, the language there that says limited to amounts required to reduce the borrower's liability? How does that affect how we read 15B2?
How it affects how we would read 15B2 is the disagreement that I respectfully have with the appeals court, and that is that we're talking about the term of a high-cost home mortgage loan. Well, there's the term of a legally originated high-cost home mortgage loan and the term of something illegally created. The two gatekeeper pre-origination sections are sections 3 and 4. And they very clearly say, thou shalt not make one of these loans unless certain conditions precedent are satisfied. So how can we say that we're going to constrict the homeowner borrower's remedies by the closing of a term of an illegal loan? And I would respectfully also argue that the borrowers
But
that.
I guess my question is, hasn't the legislature limited the borrower's remedies to those required to reduce the borrower's liability?
And what I would say to that is, yes, that is one remedy. And it also says that the borrower's liability can be extinguished entirely. And yes, that is strong medicine, but I would respectfully submit that it's a small price to pay to let these industry players understand that this court means business, that our law enforcement means business, and that if they engage in these practices, there's going to be consequences.
And do the Morrises have a continuing liability under the loan that they originally took out?
If the legislature prohibits the origination of this loan under sections 3 and 4, then they never had any liability to start with.
No, but do they now? Like, is there,
I argue that they don't.
well,
But do they get a free house? I'm confused.
right.
Do you, I mean,
As I said,
that's the tricky part of this. You don't get something for nothing. So what is their obligation? Because they don't get to stay in the house if they're not paying anything. Or is your view as punishment for the loan being excessive, the remedy is you get a free house? I'm just trying to understand what you're saying.
they did pay a lot, and they paid on an illegal loan. And they,
So how much did they pay? They paid for how long a period of time?
honestly, I don't know.
A short
Justice
period of
Caput.
time, right? It's because they got the loan in what year?
It's 2005.
So they got two-
Didn't it go up after 2? Wasn't that when the problem happened? Did it went up after 2 years?
I'm not sure when the payment spiked up, but around that period of time, I looked at the Fed's website for the LIBOR rates, and they did go up. So that's why a lot of people had a payment shock.
Mhm.
What did
but-
we do in the SJC? Did we have a remedy in the original case, not these people's case, but the
The Fremont case?
yeah, the 452 case? What was the remedy we came up with?
I have to plead ignorance to that, Justice Caffer. I don't know. I think usually in those attorney general actions, they say that the consent decree or the judgment does not bar any other rights or remedies that people that were the subject class may have.
But we didn't say
otherwise.
that the rates reduced to, because like in other predatory lending categories, I have this vague memory. There's, interest can't be beyond this. And if it is, it automatically reduces, but we don't have anything like that here. I'm just, it's just,
Well, I'd like to address your concern, Justice Caffer.
but my
Your
concern is
concern-
that, my concern is not just, we're doing cases for everybody's cases. So are there a bunch of innocent purchasers out there? Is there a bunch of title that is now in jeopardy if we rule your way? Are we, are we giving free houses away? I just don't understand what the result of this is. I
This
understand
court-
your argument. Yeah.
This court sometimes resorts to the doctrine of prospective rulings, as this court did in the Pinty case. What happened in that case was a borrower did not get the legally required notice that they have the right to bring a court action. And the way that this court handled that was that you said, well, what will happen to all the purchasers out there that have no idea that they didn't get the legally required notice? So from this point forward, I think it was July of 2015, Any notice that does not comply with that, it does void the foreclosure. And hopefully, after this holding, we trust that they will make sure that it is the required.
But like in your case, from what I understand from this record, your client received $2,000 as a settlement for that Fremont case. Is my recollection correct?
Yes,
So, but you're saying, although we don't have that settlement, that document's not going to be in this record, right? Where there's some language to the effect that you're saying, but you reserve your private remedies or something like that. We don't know if that's the case, right?
to be honest with you, I had a lot to do.
No,
in
no,
the
I
la-
understand. You've stepped in at the last second. I'm not criticizing, so.
Sure.
But I'm just trying to get a sense of. And again, you're not also aware of what we remanded Fremont. When we decided that case. You don't know what the result of that judgment post remand is not in this record, right?
Correct.
Okay.
So is your view this is a legally originated loan, and then when it ballooned, it became illegal, or was a prohibited loan from day one?
Section 3 says that no lender shall make one of these loans a high-cost home mortgage loan unless the lender receives certification from a qualified counselor that the borrower has received the counseling on the advisability of this loan transaction. Without that certification, they're not even supposed to make these loans. So Mr. Morris says that neither he nor Mrs. Morris received any counseling. And so therefore, they have a remedy, not only Section 15B, which I would argue that they do have that remedy in there, but also they can rely on Section 3 itself or Section 4, which is also a condition precedent gatekeeper to the allowance of these loans even coming into existence. So what we're saying here is the language of 15B that says that you must act within the term of a high-cost home mortgage loan to avail yourself of any of these remedies. There's not only that, but the very fact that if you are able to allege that the conditions precedent to origination didn't occur and you can prove it by a preponderance of the evidence, then that's a complete defense to the enforcement of this loan and a complete defense to the foreclosure of that illegal mortgage loan.
Even as against a subsequent assignee of the mortgage loan.
I would argue yes, because if I got a check, if the court could indulge me in this analogy, and somebody said they are giving me this check and I didn't happen to look over the endorsement and it was on the endorsement line, it said void on it. And I tried to negotiate the check with a bank teller, I wouldn't get anywhere. Same is true with a void foreclosure deed. And I understand the court's concern. What will that do? Will that cause a wave of void titles out there? And the way this court has handled that in the past is to fashion some holding where it's prospective or something like that that addresses that concern, which is, I agree, a legitimate concern for third-party purchasers who don't have any idea of what's going on here.
Okay, are there any other questions? Thank you very much.
Thank you, Your Honors.
Attorney Williamson.
Good afternoon. May I please the court? Attorney Christopher Williamson for the appellee in this matter. Like my brother, I'm going to primarily focus on the PHLPA issues of this matter. If there are any questions about other aspects, I'm happy to address them. But I think based on the court's concern and the appellate court decision prior, that's really going to be the focus of this. Turning to the clear language of the statute, the PHLPA allows a borrower to assert claims that the borrower could assert against the lender of the home loan against any subsequent holder or assignee of the home loan in two circumstances, which I believe we are all familiar with. Section 1, they may bring an original action at any time within the first 5 years of the loan, and that would be regardless of default status, whereas the second term is much more broad and doesn't essentially have a time cap besides during the term of the loan language we're now all familiar with. They can employ any defense claim, counterclaim, including a claim for violation of the statute after an action to collect on the home loan or foreclose on the collateral securing the home loan has been initiated, or the debt arising from the home loan has been accelerated, or the home loan has become 60 days in default, or in an action to enjoin foreclosure or preserve or obtain possession of the home that secures the loan. Based on the plain reading of Section 15B, the legislature in drafting it essentially has already said you can bring this claim at any point during the foreclosure process, whether that be initial default, whether that be acceleration, whether that be prior to foreclosure to enjoin, whether there's some sort of action where the mortgagee or the lender at that time during the term of the loan might have had a reason to take.
Counsel, why can't any action to obtain possession include this action, which is a summary process action by the bank to obtain possession?
Certainly. The simple answer, Your Honor, would be that it has to be during the term of the loan, and that the loan is foreclosed. And when the loan is foreclosed on, that terminates the term. Speaking
Well,
hypothetically.
it terminates the, when there's a foreclosure there, it terminates the mortgage. And so the question is, does it also terminate the loan?
Yes, because as this panel was discussing before, it's not guaranteed that the foreclosing entity is going to be the purchaser at a foreclosure. It's convenient in this matter that's before us that happened to have occurred.
But what is your legal authority for the proposition that the loan ends when the mortgage does?
Well, I think just the plain reading of during the term. I think if I am using hypotheticals as my brother
I
did.
can't, as the Morrises point out, that the term of the loan be tied to its maturity date.
Well, the maturity date can be accelerated, as is the case in this case, and as is made clear by the statute in Section 15B2, where it mentions that the loan being accelerated is a condition to bring that claim. It certainly contemplates that just because, a foreclosing entity doesn't have to wait the full 30 years if it's a 30-year loan before they bring the foreclosure. They can accelerate the debt and bring the
So
foreclosure
if
at that
you're
time.
right on your construction of during the term of a high-cost home mortgage loan, what is the meaning of in an action to obtain possession?
Certainly. I think there is some broadness to this. And, I've given some thought to it. The specific way I read it is it's a borrower bringing an action to either preserve or obtain possession. So in that case, either the borrower is bringing an action to preserve it, or potentially the mortgagee is taking possession of the property under the terms of the mortgage.
True. Why wouldn't the legislature have said in an action by the borrower?
Well, I think
obtain
Section
possession.
15B makes clear that these are all actions, which are all claims potentially brought by the borrower against the mortgagee or their assignee, going back to the first section. Some examples I thought of an action to potentially obtain possession bought by a borrower would be in situations where the mortgagee, under the rights of the mortgage, in this case, paragraph 9, took possession of the property, whether it was vacant or abandoned, or there was some sort of issues where their interest was threatened, and under the terms of the mortgage, they had the right to go in. And potentially the borrowers could have challenged that under the statute if they had it, and that would have been an action to obtain possession in that theory.
As a practical matter, isn't it true that the majority of these cases are by someone like your client to obtain possession when the person is a holdover?
Well, I think I'm not quite sure I understand what you mean, Your Honor, when it
Well,
comes
that
to
is
these
why.
cases.
Why do you think the legislature would have limited the remedies available to people in the Morris's position to situations which are not the norm?
Well, I don't
It
think
seems
that.
like the normal situation is when there's a foreclosure, you send a notice to vacate, and then whoever's there, the homeowner, doesn't vacate. And so you bring a summary process action to obtain possession. Is that not the norm?
I think that's two separate issues, Your Honor. That might be the norm in a post-foreclosure situation where the mortgagee is the foreclosing entity, but I don't believe that's what we're discussing here. We're discussing whether there are actions during the term of the loan with regard to taking possession. I think we're inputting that the legislator may have meant post-foreclosure, but that my position is that they were not.
Counsel, sorry to interrupt you, but I just wanted to, I've obviously thought about this for a while. And I guess, why would the legislature have created a remedy for people in the position of being taken advantage of by these improper loans that is not available to the majority of those people?
I'm still not sure I understand what you're saying, Your Honor, but this statute just is not one of them. That being said, they have ample time prior to foreclosure. In this
Why would we assume it's not one of them?
Because I believe that
because we're-
I disagree. I think the statute is clear that the property still has to be securing the mortgage at the time the claims are brought, and the foreclosure would extinguish
So
that the
because
property is securing that loan
the
anymore.
property is foreclosed, it no longer secures the loan.
Correct. The loan has been satisfied.
So that you really control all the terms that as the bank, if you foreclose and immediately accelerate, then they didn't do what they could have under section 1. The question is,
Agreed,
did they
but
have to?
Even after, for the next 9 years until there was a foreclosure, at any point during that period, based on the plain reading of section B, they could have brought a claim, whether to just straight to enjoin foreclosure. As we mentioned with the Pinty case, there's specific language in the default notice that they have the right to bring an action to challenge, and they did not. Just because they didn't take advantage of the options that were available to them to over a 9-year
The
period.
question is, were they smart and stayed and waited and say, okay, I'm not paying anything and I've got this other action out there. I'm not sure that they were advised this way, but their lawyer apparently told them not to pay on the mortgage.
I disagree with that. Has to be in place, and they could bring it against the assignee of the mortgage. So theoretically, if they did have claims, they could have brought it against an assignee of Fremont, in this case, my client. However, once foreclosure occurs, that terminates the term. And I believe when we look at the possibilities which could occur with bringing these claims post-foreclosure, we run into. It's clear that the borrower can only bring it against the mortgagee or its assignee. It can't bring it against a third party, whomever it is. The statute makes clear it has to be against that entity. So if a entity foreclosed, sold it to a different party, they couldn't bring those in a subsequent post-eviction action. The other aspect of that is that
I'm not sure I understand that. I thought it was the opposite of that the statute allowed them to sue assignees, right?
correct. But if the assignee, if the mortgage holder or their assignee is not the purchaser at the foreclosure, they'd be barred under the statute from bringing claims against a third party because they are not the assignee.
So I want to make sure I understand that because that's important to me. So if I have an innocent purchaser of this house, not this particular house. but-
Hypothetically, I understand.
Yeah. Those people, is their title secure?
Recording in progress.
Generally speaking, is much different than based on claims under the PHLPA. Under the claims under the PHLPA, I would say, yes, it is secure.
Well, only if we adopt your interpretation. If we
Under
don't
my interpretation, which I believe,
adopt your interpretation, are those third-party people protected under some other provision in the PHLPA?
not that I'm aware of it, except I think the statute is explicitly clear that it must be raised against a mortgagee or assignee during the term of the loan. The other aspect of it that I found interesting is that Section 15B2 specifically mentions that, the borrowers can employ any defense claim or counterclaim. It expressly leaves out any third-party claims, meaning that if there was a summary
Sorry,
process.
can you repeat that?
Yeah, I
It expressly
apologize.
leaves out what?
It expressly does not list third-party claims, meaning that if there was a post-foreclosure summary process action brought by a, let's say, bona fide third-party purchaser against the homeowners couldn't then bring third-party claims against the foreclosing entity because those claims would be barred under the specific language of that. The third-party claims are not, aren't mentioned as something they could bring, which adds further finality or adds further argument to the finality aspect of the statute that the term of the loan ends at foreclosure. That the owner of the property, once there's foreclosure, is the title owner via the foreclosure deed that's recorded. The mortgage has been extinguished. I think to say that the mortgage extends beyond that date, I think would run into some serious issues. While it might benefit the borrowers in this situation theoretically, if a property foreclosed for $150,000 and there's $250,000 due on the loan, could the mortgagee still look to collect payments from it because there's money due? No, they couldn't, because there's a situation and there's a statute in place for deficiency actions. The term is ended. If the loan wasn't fully satisfied, the foreclosing entity would have to do what was statutorily required to bring a deficiency action, but they couldn't expect payments under the term of the loan post-foreclosure.
But doesn't the deficiency action suggest that while the mortgage is extinguished, the loan still exists?
No, I disagree. That'd be the same as if, any situation where, you received a judgment, weren't paid in full, and brought an action to recover the rest. There's a finality in what occurred before. There's a finality in the foreclosure. You just haven't, the foreclosing entity just did not recoup the full amount they could have and has the right to pursue more if they choose to do so. My experience has been that often they do not.
Isn't that the point? That they can. So the mortgage is extinguished, but the loan remains outstanding. So your client gets to try to get their money. I mean, they can't under this probably because it's predatory, but when you're out there normally doing this on a permissible loan and a mortgage, it's not extinguished, right? The loan still is out there.
I disagree. It is extinguished
Well,
because
give me a case, because whether you disagree with me or not, I think we have cases that say that the loan is not extinguished even by the mortgage disappears, but the loan doesn't, right?
I disagree. I'm happy to supplement with a case if I could find one. But as a practical matter, once foreclosure occurs, the total debt due is locked in at that point. So the deficiency judgment is securing a sum certain that is based on what financials were available at the time of foreclosure during the time of the loan, not afterwards, which runs to the hypothetical I was speaking, whereas if a mortgagee, instead of a deficiency action, tried to collect additional payments that were due or interest that survived beyond, that would be outside of the term of the loan. They couldn't do so.
I'm gonna sort of make this as simple as I
Sure.
possibly can for myself and for no one else. During the term of a high-cost mortgage loan, if the mortgage extinguishes at the foreclosure, does the loan still exist? You say no, but you can bring a deficiency action to collect the outstanding amount that wasn't recouped at the foreclosure. So
Yes, that's.
so
apologies.
what I'm looking for is a case that says, context of an efficiency action, or whatever context, that even though there can be a deficiency action, the loan no longer exists. The foreclosure distinguishes not just the mortgage, but the loan, because that would really help inform us what 15b2 means.
I understand, Your Honor. As I stand here today, I'm not aware, but if the court would allow, I'd like the opportunity to supplement if I could provide a case for them.
It seems to me, and this might be an overstatement, I'm not sure it's a case, I think it would be the case,